Hello, everybody.
Mr. Maybe, Mr. Hartel needs to speak with you, so I'm going to put you both into a breakout room for a moment, okay?
Okay, gotcha.
Okay, court calls the people of the state of Michigan versus Robert Darren Maybe, case number 2514666 OM. Mr. Maybe, are you able to see and hear the court?
Yes, I am.
So we're here for a couple different things today. My understanding is we're going to plead to a bond violation and the underlying offense. Is that correct, Mr. Hartel?
It is.
All right. Mr. Maybe, I have a bond violation that alleges that on or about April 23rd, 2025, that you did test positive for alcohol. I had placed you on bond on this case on April 21st, 2025. And one of the conditions that I placed upon you was that you were not to consume alcohol and you'll be subject to random testing. Do you understand those bond violations?
Yes, I do. Yes,
Mr. Hartel, how does your client wish to proceed on the bond violation?
On the bond violations, he'd be wishing to plead guilty, Your Honor.
Is that accurate, Mr. Maybe?
Yes. Yes.
Then to the allegation that on or about April 23rd, 2025, you tested positive for alcohol, how do you plead?
Is this for the bond violation?
This is the bond violation.
Okay, guilty.
And did you consume alcohol around April 23rd? So that would have been Wednesday, 2 days ago.
Oh, yes, I did. Yeah.
Okay.
Afternoon.
And you knowingly did that?
Correct. That's why I want to plead guilty.
And you knew that pursuant to the terms of your bond, you were not to consume alcohol?
Correct.
Do counsel believe the defendants provided a factual basis in which to accept the bond violation plea?
Yes, Your Honor. Yes, Your Honor.
As does the court. Sir, I find that you are in violation of your bond for consuming alcohol back on April 23rd, 2025. It's also my understanding that we're anticipating a plea on the underlying case.
That is correct, Your Honor.
Mr. Carnes?
Yes, Your Honor, I anticipate that Mr. Maybe will be pleading no contest as charged. The reason for the no contest plea is intoxication, lack of memory due to intoxication at the time of the offense. And the people are simply asking for 15 days jail with no probation. That was communicated to defense during negotiations. Thank you.
Is that a Killebrew or just a recommendation?
It's just a recommendation, Your Honor.
Mr. Hartel?
That is accurate, Your Honor.
You said no probation.
Yes, sir.
Mr. Maybe, have you heard what the attorneys have said in this matter is the resolution to the underlying case?
Yes, I have.
And is that how you wish to proceed?
Yes, no
Will you
contest.
please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Maybe, back on April 18th, 2025, were you on probation or parole?
No,
Were you on bond in any other case?
no,
Other than the plea agreement with the recommendation, has anybody promised you anything in order to get you to plea today?
no,
Has anybody threatened you in any way in order to get you to plea?
no.
And is it your own free choice to plea today?
Yes, Your Honor.
Then to the count or that on or about April 18th, 2025 in the city of Cadillac, Westford County, you were intoxicated in public, in particular the parking lot of Harborview Apartments. How do you plead? I anticipate you would plead no contest.
Yeah, no contest.
in order to accept that plea, I must have something to review that tells me that gives me enough evidence to find you guilty. I have been provided with what's been previously marked as People's Exhibit Number 1. That is a Cadillac City Police Department incident number 2500982. Do the people move for submission?
Yes, Your Honor.
Mr. Hartel, any objection?
None.
Mr. Maybe, do you understand that by entering a no contest plea, I am able to review this police report to determine whether or not there's a factual basis, and I'm also able to use that for sentencing purposes. Do you understand?
Oh, yes, okay,
Prior to recalling the case, I had been advised by counsel that this was going to be a no contest plea, so I had taken the advantage to review the report ahead of time. I find that the defendant is guilty of being intoxicated in public. I find that the plea is knowing, voluntary, and accurate. I also find that the interests of justice are served by allowing a no contest plea due to the level of intoxication and lack of memory. In particular, the police report indicates that a PBT was administered and it came back at a 0.191. Additionally, I find that the police were called to the Harborview Apartments due to a disturbance on February 18th. Harborview Apartments are located here in the city of Cadillac. It does appear that this argument was over the old, it's referenced as a show, but I remember it as a movie of Howard the Duck. It's also indicated in the police report, described the defendant as having the smell and odor of consumed intoxicants. He had bloodshot, watery eyes. He appeared to have difficulty understanding the questions. He had to think about the question, then asked whether he needed to think about it. He asked, think about what? So given the level of intoxication and his interaction with law enforcement that day, I find that his lack of memory is a valid reason to enter the no contest plea. Mr. Maybe, I find you guilty of intoxication in public, the 90-day misdemeanor. And again, I previously found you in violation of the bond condition. Mr. Hartel, any allocution?
Yes, Your Honor. I would ask the court to adopt the people's recommendation of 15 days. I do believe that would be appropriate. If I recall correctly, the amount of time he has is about 6 days, so that would put him with good time about halfway through. I understand the way the jail does the good time at all, but I do believe that would be appropriate. He did commit the offense of being intoxicated in public. As the people did note, and as the court did read, it wasn't the most extreme case, perhaps, but we do acknowledge that he did violate bond as well. I do believe that he has a lot of work ahead of him to get to the point he needs to be. He has been working with community mental health, which is part of it. It goes deeper than just alcohol addiction, but he is working with them. He has been working for what we can do with our office social worker, Mr. Brian Henniger, but it's a lifelong struggle, and I just wish him the best. Thank you.
Mr. Carnes?
Thank you, Your Honor. I do note that Mr. Maybe caused concern to at least 2 people, and then took up law enforcement time for a bit as well in this. I think 15 days jail is appropriate here. Ultimately, I wish Mr. Maybe would stop drinking, but I don't think he's a good candidate for probation. Thank you.
Mr. Maybe, I realize you took a no contest plea, but is there anything you'd like me to know before sentencing?
I feel terrible because I know Howard personally, and I know he's going through a hard time, so he's a friend of mine, and I'm shocked by this whole circumstance. I'm kind of upset at myself. He probably didn't need that stress of me that day.
When you say you know Howard personally, are you talking about Howard the Duck from the movie you know personally?
That's one of his nicknames amongst his friends. Like, he does a lot of tree work, so he knows a lot of the same people I know.
So when you say Howard, you're not talking about Howard the Duck from the movie. You're talking about somebody that you know has a nickname of Howard the Duck.
Correct.
Okay. Thought we had a competency issue there for a minute.
Sorry, I giggled.
Okay. Well, historically, the defendant has a domestic violence from 2006, a malicious destruction of property, 200 to 1,000 in 06, a domestic violence in 15, a littering objects in the pathway of a vehicle from 2017. I specifically remember that case because Mr. Maybe was throwing chunks of concrete onto Mitchell Street at moving vehicles. In 17, there was a malicious destruction of property less than $200. In 19, a retail fraud third. 19, a disorderly drunk. In 23, an attempted larceny less than $200. In 24, a malicious destruction of personal property less than $200. In 24, disorderly drunk. In 24, another disorderly drunk. In 09, which does not show on his CCH, but does show in our local records, there was a disorderly person. There is no question that alcohol is playing a major factor in Mr. Maybe's life here, and it has for a very long number of years. I do realize in the past he has worked with CMH. I remember one probation violation in particular where he was given the opportunity to work with CMH and that didn't work out, which resulted in a probation violation. Additionally, in this case, he was ordered not to consume alcohol, and 2 days later, we're back drunk in public again. I don't believe that Mr. Maybe is a good candidate for probation. And I realize there was a recommendation for 15 days jail, but given his history, his performance on prior probations, and his performance on bond in this matter, the court will not follow the recommendation. I will order 45 days jail with credit for 6 days. There is a $75 crime victims' rights fee, a $50 state minimum fee, and Mr. Maybe, I will keep the fines and costs at $100 fine, $100 cost. Mr. Hartel, attorney fee.
Wait, John.
Mr. Maybe, because I have sentenced you to a term of incarceration, you have the right to appeal that decision. And if you decide that you want to appeal that and need the assistance of a public attorney because you cannot afford one, you have 14 days in which to file the request for the appointment of a public defender. Additionally, any balance that remains unpaid for 56 days will receive a 20% penalty. I also show that you owe this court $2,270.39, and there's been no payments made on those fines. So I would request that once you get out of jail that you contact the court and start making payment arrangements. Mr. Hartel, anything further?
No, thank you.
Mr. Carnes?
No, Your Honor.
Thank you, Jail.
Thank you guys for coming out. Be safe, be well, sleep sweet, and much love.